If you've been arrested for domestic violence in California, you've probably already Googled your charges and seen the worst case scenario. For felony domestic violence, up to 4 years in state prison, and even for misdemeanors, it's up to a year in jail. That's terrifying. But what comes next after your arrest isn't always trial, and it definitely isn't always a conviction. In most cases, what you're walking into is a negotiation, a process to resolve your case, and if it's handled strategically, it is your chance to protect your record, your job, and your future. By the end of this video, you will understand exactly how these negotiations work, why that first offer is almost always a trap, and how over 95% of my clients last year who signed on with us, whose cases were resolved, were able to avoid a conviction entirely. My name is Veronica. I'm a domestic violence criminal defense attorney, and I help people across the entire state of California put their cases behind them so that they can enjoy their lives and their freedom. Okay, so let's jump right in. How settlement negotiations work for domestic violence cases in the state of California. Now, let me be clear that if you want the best possible outcome, the smartest thing you can do is hire an attorney before your first court date, because that gives us a window to contact the district attorney and sometimes even get the case dropped before charges are filed. But if you've already had that first court date or it's coming up fast, let me show you what you need to know. We're going to go over how prosecutors push early offers, what those offers really mean, and how to push back in the right way to protect your future and your record. So let's jump in. The first court date. For a lot of people, the very first court date is the first time that they even learn that charges have actually been filed against them. You will walk into a courtroom. If you don't have a private attorney, you will be assigned a public defender, someone who likely has 20 other cases or more to deal with that day. At that point, although your attorney will usually be handed a police report, you have not seen any police reports, any video, body-worn video, any medical records. And in many courtrooms, the prosecutor will give your lawyer an offer. Often it's written on a sticky note attached to the police report that they just handed over. That's it. And that offer, it almost always includes a conviction, sometimes jail time, almost always probation, almost always 52 weeks of domestic violence classes that you have to pay for and attend in person, a $500 fine. And that conviction that comes with that offer, that can never be expunged, whether it is a misdemeanor or a felony, not ever in the state of California. To make things worse, the DA will often say, this is an arraignment-only offer. If you do not take this offer today, then the deal is going to get worse. Now, arraignment is what that first court date is called. So they want to scare you. They want you to take the deal before you or your lawyer has even had a chance to see the evidence, often before the DA themselves has actually looked at the evidence. Sometimes they will announce this offer out loud in front of the judge and everyone else in the courtroom when your case is called. They'll say something like the offer is 30 days in jail, 5 years of probation, plead guilty, etc. And suddenly, when you hear that, when you have not had a chance to digest what's going on, when you haven't seen the evidence, your stomach drops. And I've sat in these courtrooms. I've seen it happen to hundreds of people. More than half will just take that first offer. And for the DA, that's a dream. They just cleared a case without doing any real work. Let's get into an example of how this plays out. Fran and Dan got into an argument late one night. A neighbor called the police. Dan was arrested, spent the night in jail, and waited weeks before his first court date. Now, the morning of court, without ever seeing the police report, without knowing if there were photos, videos, Dan was offered 5 years of formal probation, 52 weeks of classes, and along with that, a permanent conviction for a felony on his record. He was told it was a take it or leave it offer, and that he was lucky that it didn't include jail. So Dan panicked and he took it. That decision cost him his job and followed him into every job interview after that. And the worst part is that his case might have been defensible, but no one ever looked. Do not let that be you. I'm here to tell you, you do not have to take that first offer. And in most cases, you absolutely should not. Why the first offer is almost always bad. In my nearly 13 years as a criminal defense attorney, I have not had a client take that first offer on the first court date. Why? Because it's like walking onto a car dealership parking lot and paying full sticker price. Now imagine this before COVID and the chip shortage. The DA throws out a number, 30 days in jail, a conviction, whatever, in hopes that you will panic and sign. Now, not only is agreeing to that, to the very first thing that they throw out, like just accepting paying the price that's on the car window, but you don't even know what the car has under the hood yet. You haven't driven it. You haven't had it inspected. In your case, you haven't seen the body-worn camera footage. Your attorney hasn't either. You haven't seen if there are any motions that could be filed to get rid of some of the evidence and to make the prosecution work for it if they want a conviction. You haven't seen whether there are holes in the case. And yes, your attorney will generally, in most counties in California, get a copy of the police report. But the problem is that the police report often is wrong. Not just a little wrong, but seriously distorted. For my cases, I'm not going to just trust what's in the police report. I want to see what's on the body-worn video. I want to see what actually happened, not have it filtered through a police officer whose duty it is to gather evidence against my client. So when you are given an offer that you are told is an arraignment-only offer on your first court date, what should you, or really your attorney, do in that moment? You do not enter a plea. You ask the judge to continue the arraignment, to set another arraignment. That's basically the loophole here, and generally the DAs are going to be okay with that. You push it out 30 to 45 days so your lawyer can demand the full evidence from the DA. That's when the real work begins. Now let's get into an example of this and why this is so important. Jen and Ben had been drinking at a friend's wedding. They got into a shouting match back at their Airbnb. Someone overheard and called the police. Police come out, Ben ends up getting arrested. At court, the first court date, the DA hands over a plea offer. 3 years of probation and a misdemeanor domestic violence conviction. But Ben knows he never touched Jen. And she told the officers that, but it didn't matter. They arrested him anyway. And the police report twisted things. The police report made the whole thing sound worse than it was. It justified Ben's arrest. But his attorney pushed back, got the body cam footage, and showed that Jen was calm, not injured, and that the police report quoted her inaccurately. The result, no conviction, no probation, a few anger management classes that Ben had already done, and the case is dismissed. The strategic phase, how real negotiation works. Okay, I only do domestic violence defense. That is it. That's what I do. So when I take on a case, I immediately start crafting a strategy. Step one is generally going to be mitigation. Before we even walk into the courtroom, my client is already doing work. Couples counseling, if they're still with the alleged victim, maybe online domestic violence classes, sometimes therapy, depending on the client and the case. I want to show the DA this person is not a criminal. They're a good person who had a bad night, and they are already doing the work to make sure that they are never in this position again. Doesn't mean that you're guilty. Doesn't mean I'm saying that you're guilty. I'm saying so that you're never in this position because obviously you do not want to end up arrested again. You don't. A lot of people don't care, but you don't. Meanwhile, I'm examining every detail of the case. Then I approach the DA with a reasonable offer, something that does not involve a conviction. Maybe a few classes, maybe a short informal diversion program. The goal for every single one of my clients is to avoid a conviction, a dismissal without ruining your life. And unlike many attorneys who only talk to the DA in court, I found that when I reach out between court dates over email, the DA will actually have time to review my client's materials and evaluate the case in a more thoughtful way. I'm not rushing them. And that makes my client stand out because most attorneys don't do that. They line up when they get to the courtroom. The DA has maybe 25, 30, maybe even 50 cases to go over. They're not going to have time to look at all that mitigation and see that you are one of the people who deserve a second chance. And when they're rushed, generally they default to wanting a conviction, to wanting jail time, to not going along with what the defense attorney wants for their client. Let's get into an example here. Ray and May were arguing in their apartment. At one point, May tried to leave, and Ray stood near the front door to keep talking to her. She felt blocked in, got upset, and called 911. The police showed up, Ray was arrested, and the report made it sound like he was physically threatening. But it wasn't true. What really helped was that they had a home security camera in their living room pointed at the front door. The footage showed that Ray never touched her, and although he was standing in the doorway, he didn't appear to necessarily be intentionally blocking her exit. Plus, although it wasn't noted in the police report, they had a back door that she could have left from if she really wanted to leave the house. He was upset, sure, in the video, but not violent. Meanwhile, Ray had already started therapy, enrolled in a short online domestic violence class, and that made a big difference. When all of that, the footage, the counseling, the context, was sent to the DA ahead of court, giving the DA time to actually review it and think about it, the entire conversation changed. Instead of a conviction, the offer became a dismissal. No record, no jail, just credit for what he'd already done, and he was able to move on with his life. Now, what about when the DA just won't budge? Sometimes the prosecutor just won't give you what you want. Maybe they're stubborn, maybe they're lazy, maybe they're afraid of looking soft. That does not mean that it's the end of the line. Here are some of the things that we can do. File a motion to suppress your statement if you were never read your rights. Set up a meeting with the DA's supervisor. Speak to the judge in chambers and bring them in to pressure the DA to show them that hey, if we can't work this out, if you're going to push my client to take a conviction, and my client cannot do that because it will ruin his future, we're going to have to take the case to trial, which takes up a lot of resources from the court system and from that judge. You can also file a motion for mental health diversion if you qualify, where generally for my clients, you do therapy for a period of time and end up getting a dismissal. Now, these are not guaranteed wins, but these are options. Sometimes in these cases, you just need to show the DA that this case, if they're not going to give you what you're asking for, and what you're asking for, by the way, is very reasonable, then it's going to be a lot of work for them, and they will start negotiating again. Here's an example of how this can play out. Darren and Karen got into an argument outside of their house. A neighbor called the police. By the time that the officers arrived, things had calmed down, but they separated the two and started asking questions. Darren made a few comments to the officers without realizing that they could be used against them, or that they actually sounded a lot worse than he intended. Now, he's at his house, but he had not been read his rights. So his attorney filed a motion to suppress those statements, arguing that Darren was effectively in custody, meaning a reasonable person would not have felt free to leave when he spoke, and that the officers then should have read him his rights. Now, this forces the DA to either file an opposition, spending time on that, and they also realize that if they lose this motion, if the defense is able to get those statements suppressed so that they cannot be used in court, they lose one of their key pieces of evidence. Now, they still have other evidence likely, like victim statements, 911 call, the neighbor as a witness, any photographs that the police took. But the case suddenly becomes more work, more risk. And the result is a better offer. No conviction, just a few classes, and a full dismissal. Now, every case is different. That is just an example, but one smart legal move can make the difference between walking away with this just being a blip on the radar and something that changes the trajectory of someone like Darren's entire life. Domestic violence cases are not situations where you just roll over in plea negotiations. You exhaust every option before you accept something that will haunt your record and you forever. Look, a domestic violence arrest does not make you a bad person. It doesn't mean that the rest of your life is ruined. But if you take a conviction without a fight, that could follow you forever in your career, immigration status, personal life, and it's going to be something that you will be explaining for the rest of your life. The justice system does not give out favors, but it does respond to strategy, and strategy is what I do. If you are facing a domestic violence charge and you are serious about protecting your future, feel free to call my office. You can book a free consultation via the link down below. You can also find our number there. I hope you found this video helpful. If you did find it helpful, please don't forget to like, subscribe, ring the bell, and if you have a question or a comment, leave it in the comments.